What special visitor visa for offshore energy platforms lets visitors come to the U.S. to work without paying taxes? The B-1 Offshore Continental Shelf, or OCS, visa is an immigration classification with deep roots in the development of U.S. offshore energy policy and law. Though it may seem niche or obscure today, its origins date back to legislative frameworks established during the mid-20th century, particularly the era of burgeoning offshore resource exploration. To understand this visa's purpose and significance, we must explore the historical, legislative, and policy context that shaped its creation. The journey of the B-1 OCS visa begins with the enactment of the Outer Continental Shelf Lands Act, OCSLA, in 1953. This legislation was a landmark move by the U.S. government to extend jurisdiction to the Outer Continental Shelf, encompassing submerged lands, subsoil, and seabed beyond U.S. territorial waters, but within its exclusive economic zone. The OCSLA was enacted to provide a legal framework for managing the vast natural resources in this region, especially oil and natural gas, which were becoming increasingly vital to national energy security. Under OCSLA, federal laws were extended to offshore areas, ensuring that U.S. labor, safety, and environmental standards applied to operations in these zones. However, the unique geography of the OCS, neither fully part of the U.S. mainland nor entirely foreign, posed challenges. These complexities would later influence the development of immigration classifications like the B-1 OCS visa. By the 1950s and 1960s, advances in technology made it possible to extract oil and gas from offshore platforms. This led to an energy boom, with companies building and operating facilities in the waters governed by OCSLA. As the offshore industry grew, so did the need for highly specialized labor, engineers, technicians, and project managers, who often hailed from various parts of the world. Rather than hiring exclusively U.S.-based workers, energy companies frequently contracted multinational specialists familiar with the complexities of offshore energy production. These professionals, while crucial to operations, often worked on temporary assignments, creating a need for a visa classification that addressed their unique circumstances. The incidental to business provision originally referred to activities that were essential to the completion of a business project, but didn't qualify as employment under traditional U.S. labor definitions. In the case of the B-1 OCS visa, this provision was meant to address the unique needs of offshore energy operations, where work often took place outside U.S. territorial waters and involved temporary specialized tasks. Catering and support services, including cooks, fall under this provision because they are considered essential to the functioning of offshore operations. Energy companies typically rely on comprehensive logistical setups to support workers on rigs or platforms which are isolated from mainland resources. Providing meals, maintaining accommodations, and ensuring the well-being of the crew are critical to sustaining operations, even though they may not directly involve resource extraction or technical expertise. From a legal and policy perspective, these roles are ancillary or secondary to the core business of energy production. However, they remain indispensable, aligning with the broader interpretation of what constitutes work incidental to business. The flexibility of the incidental to business provision has been both a strength and a source of scrutiny. Over time, the B-1 OCS visa's application has expanded to cover a wider range of roles, as long as they remain tied to the operational needs of offshore platforms. This includes not just engineers and technicians, but also logistical and support staff like cooks and cleaners. This broader application reflects the practical realities of offshore work, but it has also raised questions about whether the provision has been diluted. Regulatory efforts in the 2000s sought to reinforce the visa's original intent by tying its use specifically to tasks essential to offshore energy operations. However, support services like catering continued to qualify, as they are vital to maintaining the operational integrity of offshore platforms. The offshore nature of the work performed under the B-1 OCS visa also creates unique tax implications. Workers in this category are typically classified as non-resident aliens for tax purposes. Since their income is earned outside U.S. territorial waters, It is often exempt from federal income tax. Furthermore, without SSNs or tax withholding obligations, these workers are not part of Social Security or Medicare systems. This arrangement aligns with the overarching principles of the OCSLA to ensure U.S. jurisdiction and standards over offshore activities without imposing unnecessary administrative burdens or conflicting with international employment practices. In the decades following OCSLA's passage, U.S. immigration policy evolved to address challenges and prevent misuse of visa classifications. By the 2000s, regulatory clarifications reinforced the distinct purpose of the B-1 OCS visa. It was explicitly tied to the operational needs of the offshore energy industry and separated from broader employment-based visas. These refinements ensured that the visa remained a practical tool for multinational companies operating offshore, allowing them to leverage global talent while adhering to U.S. laws. Today, the B-1 OCS visa stands as a specialized solution for a highly specific need within the U.S. economy. Requesting the B-1 OCS visa begins with completing the DS-160 form, a standard application for U.S. non-immigrant visas. Applicants should specify that their visit relates to business activities on the Outer Continental Shelf. Typically, they select Business B-1 as the primary visa type and provide details about their offshore energy operations in the appropriate section. Supporting documents. To align with the Incidental to Business provision, applicants must provide evidence of their role and its connection to offshore work. These include letter from the employer or sponsoring company. This letter should outline the nature of the work, its location on the Outer Continental Shelf, and its temporary duration. It must specify that the applicant will remain employed and paid by their foreign employer, not a U.S. entity. Proof of offshore work or contract. Evidence such as contracts or agreements showing the employer's connection to offshore energy projects. Details of the role, a job description, explicitly tying the applicant's role to essential offshore tasks, for example, engineering, technical consulting, or support services like catering. Proof of qualifications. Certifications, licenses, or relevant experience demonstrating the applicant's ability to perform the specialized work required. The B-1 Offshore Continental Shelf (OCS) visa offers a unique lens through which to examine the complexity and dynamism of U.S. immigration policy. Designed to address the specific demands of offshore energy production, this visa is more than a legal classification. It is a testament to the interplay of law, economics, and international relations. Its origins and continued relevance illustrate the balance policymakers must strike between competing priorities: fostering economic growth, maintaining labor protections, and ensuring the system aligns with global realities. At its core, the B-1 OCS visa is a pragmatic solution to a practical problem. Offshore energy operations require specialized skills and support services, often supplied by a global workforce. By enabling international professionals to contribute without being fully integrated into the U.S. labor market, the visa supports critical industries like oil and gas while mitigating concerns about domestic job displacement. Yet this flexibility also exposes fault lines, particularly in the broad interpretation of incidental to business. The inclusion of ancillary roles, such as catering, exemplifies how adaptability can blur the lines between necessity and convenience, raising questions about whether the provision's original intent has been diluted. The visa also underscores the patchwork nature of U.S. immigration policy. Built on the foundation of the Outer Continental Shelf Lands Act, the B-1 OCS classification reflects how immigration laws are often tailored to meet sector-specific needs. This approach allows for targeted solutions but also reveals systemic tensions. For instance, the classification of workers as non-resident aliens avoids double taxation and minimizes administrative burdens, but also circumvents traditional labor protections, such as contributions to Social Security and Medicare. These trade-offs highlight the inherent conflicts between national economic efficiency, global competitiveness, and the welfare of the domestic workforce. In many ways, the B-1 OCS visa serves as a microcosm of the broader immigration system. It illustrates how policies evolve to address emerging challenges while navigating the pressures of inclusivity, sovereignty, and economic pragmatism. As interest groups from multinational corporations to labor advocates exert their influence, immigration law becomes a living, adaptive framework, constantly balancing the diverse priorities of its stakeholders. The B-1 OCS visa's continued use demonstrates the necessity of such adaptability. However, it also calls attention to the need for vigilance and oversight to ensure the system remains fair and effective. Its story is one of compromise and innovation, reflecting the broader narrative of U.S. immigration policy as a dynamic system shaped by shifting economic needs, societal values, and geopolitical realities. Ultimately, the B-1 OCS visa invites reflection on how immigration policies can both respond to specific demands and embody the broader ideals of equity and opportunity in an interconnected world.